Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with an important update from the Supreme Court, which today pronounced the much anticipated judgment in the same-sex marriage case. You already know that in May this year, the 5-judge bench comprising CJI D.Y. Chandrachud and Justices Sanjay Kishan Kaul, S. Ravindra Bhatt, Hima Kohli and P.S. Narasimha had reserved its judgment after rigorous deliberation. Today, the bench pronounced 4 judgments written by the CJI, Justice S.K. Kaul, Justice Ravindra Bhatt and Justice P.S. Narasimha respectively. As per the verdict, the court refused to grant the right to marry to queer couples. However, 4 out of the 5 judges agreed to direct the Union of India to constitute a committee to examine the rights and entitlements of persons in queer couples, without legal recognition of their relationship as a marriage. Here are a few highlights from the judgment. The CJI, in his judgment, which Justice S.K. Kaul concurred with, held that the court could not strike down the provisions of the Special Marriage Act because it falls within the domain of the Parliament and the legislature. However, he recorded the statement of the Solicitor General appearing for the Union that the Union government would constitute a committee to decide the rights of persons in queer unions. Further, the CJI also held that transgender persons in heterosexual relationships had the right to marry under the existing laws, including personal laws, and that unmarried couples, including queer couples, could jointly adopt a child. In that context, Regulation 5 Clause 3 of the CARA regulations, insofar as it prohibited unmarried couples from adopting, was in violation of Article 15 of the Constitution. But Justice S. Ravindra Bhatt disagreed with the CJI on this point, saying that Regulation 5.3 of CARA was not unconstitutional. Justice Bhatt, in his judgment, which Justice Hima Kohli concurred with, held that marriage was a social institution and there could not be an unqualified right to marry which was to be treated as a fundamental right. He reiterated that queer couples had a right to relationships, but also said that a gender-neutral interpretation of the Special Marriage Act was not equitable and could result in women being exposed to vulnerabilities in an unintended manner. While recognizing that denial of benefits such as PF, ESI, pension, etc. to queer partners may have an adverse and a discriminatory effect, Justice Bhatt stated that addressing these concerns may involve a range of policy choices and thus the high-powered committee formed by the Union should examine these aspects. Justice P.S. Narasimha, agreeing with Justice Bhatt, stated that there existed no unqualified right to marry and that the right to marriage was a statutory right or flowing from a custom. On the aspect of CARA regulations and the right of queer couples to adopt, he also stated that the regulations could not be held as unconstitutional. To read the entire judgment in detail, you can visit our website at livelaw.in. Do comment and tell us about your views on this matter. In another important update, the Supreme Court today reserved for order the bail plea of former Delhi Deputy Chief Minister Manish Sisodia, who is facing money laundering and corruption charges over alleged irregularities in the framing and implementation of now scrapped liquor policy in the national capital. A bench of Justices Sanjeev Khanna and S.V.N. Bhatti has been hearing Sisodia's pleas against the Delhi High Court denying him bail in both the CBI and ED cases. In the final arguments that took place today, Senior Advocate Dr. Abhishek Manu Singhvi, appearing for Sisodia, submitted that there was nothing to show that Sisodia insisted on the license being given to Indo-Spirits violating the law, that there was no allegation of bribery against Sisodia in the CBI predicate offence under the PMLA, that the allegation of bribe of 220 crore with regard to modification of liquor policy with regard to airport licenses was not a part of the predicate offence or you can say was not a necessary element. The court further said that if bribery was not there in predicate offence, then it would be difficult to prove the PMLA case. Additional Solicitor General S.V. Raju responded to this by arguing that as per Section 66(2) of PMLA, ED can intimate the jurisdictional police about any new information. He also informed the court that the trial could be finished in 9 to 12 months. The judgment has been reserved today. For more details, you can visit livelaw.in. Today was the fifth day of hearing a plea filed by former Andhra Pradesh Chief Minister Chandrababu Naidu for quashing of FIR in the skill development scam case. A bench comprising Justices Aniruddha Bose and Bela M. Trivedi heard the matter. Naidu has challenged the order passed by Andhra Pradesh High Court, which had declined to quash the FIR against him in the case. Senior advocate Mukul Rohtagi, appearing for Andhra Pradesh CID, argued that Section 17A of the Prevention of Corruption Act was not applicable in the case because it was not in existence at the time when the offence occurred, that is in 2015-16, and it was not retrospective. That the section was meant as a protection from harassment for honest public servants so that they may not hesitate to take correct decisions, and not to protect them from corruption. He also said that the FIR mentions several offences under the IPC. Within 5 days of the petitioner being added as an accused, the quashing petition was filed. This was completely premature and did not give reasonable time to police to investigate the case. Rohtagi also quoted certain judgments to support the contention that when a person is accused under the PC Act and IPC, even if for some reason the offences under PC Act are dropped, the special judge is competent to keep trying them under the IPC. Further, senior advocate Harish Salve argued on behalf of Naidu. On retrospectivity, he said that a retrospective legislation is one that impairs past rights. Rights are between citizens and upon citizens. Between state and citizens, even a substantive law is considered to be retrospective if it confers new rights. He also contended that the assumption that Section 17A would only apply to innocent people was not correct, as an entire inquiry would have to be conducted first to determine their innocence, and that there was not a single judgment that allowed a special court to try a case against a public servant without the prior sanction. The court has today reserved the judgment in the case. The court also had to hear the plea by Naidu for anticipatory bail in the FiberNet scam case. But due to paucity of time, the hearing was adjourned to this Friday with an assurance that Naidu would not be arrested in this case till then. The Delhi High Court has allowed the appeal by Aam Aadmi Party MP Raghav Chadha challenging the trial court order, which granted nod and paved way for the Rajya Sabha Secretariat to evict him from a government bungalow. A suit was filed by Chadha against the Secretariat challenging a letter issued in March this year, cancelling the accommodation allotted to him. An interim order was passed in the same, directing the Secretariat to not dispossess him from the government bungalow without due process of law. But last week, Additional District Judge Sudhanshu Kaushik of Patiala House Courts vacated this order. So Chadha now appealed before the High Court challenging the same. He had argued that he was selectively targeted in being evicted when there were other first-time MPs as well with identical accommodation above their entitlement. After hearing the senior advocate Abhishek Manu Singhvi for Chadha and Additional Solicitor General Vikram Banerjee for the Rajya Sabha Secretariat, Justice Anup Jairam Bambani had reserved the order last week. Today, the appeal was allowed, directing Chadha to present the plaint before the trial court within 3 days and the trial court to proceed with the matter. Also, while adjudicating the question as to whether Rajya Sabha Secretariat is government or a public officer within the meaning of Section 80 of CPC, the court said that in this case, as the Rajya Sabha Secretariat was sued through the person that heads it and who would act on its behalf, the name of the Secretary General appears as that person. That, however, does not mean that the defendant in the suit is Secretary General. Clearly, the defendant is the Rajya Sabha Secretariat. The Supreme Court adjourned until January next year an appeal by the CBI challenging bail granted to RJD chief and former Bihar Chief Minister Lalu Prasad Yadav in a Fodder scam case. A bench of Justices A.S. Bopanna and M.M. Sundaresh was hearing a batch of pleas against the orders granting bail to the former legislator. On the last occasion, senior advocate Kapil Sibal, appearing for Yadav, had argued that he could not be asked to go back to jail on account of his advanced age and the time already served. In another update, the Supreme Court has issued notice to the centre in a public interest litigation filed challenging certain provisions of Assisted Reproductive Technology Act of 2021. Under this act, a gamete bank cannot supply the sperm or oocyte, that is female egg, of a single donor to more than one commissioning couple, that is the couple which cannot conceive a child naturally or due to medical reasons. The PIL contends that provisions of the new act and rules will lead to a scarcity of donor semen samples, which will lead to increase in price for treatment, making assisted reproductive techniques unaffordable for common people. The PIL points out that before the act came into force, the price per cycle of treatment was close to 3,000 rupees. But with the new provisions, it is predicted to escalate up to 20 to 50 times, since one donor can donate only to one couple. The plea further states that it is not logical to club the female egg and sperm banking under the act, as both procedures require different skill sets. Sperm banking is a simple procedure and hence economical, while female egg banking is a complex and invasive procedure and hence requires a more elaborate setup and expertise. And hence, the new act may be logical with regard to female eggs, but it is devoid of any merit when it comes to sperm donation. A bench of Justice B.V. Nagaratna and Justice Ujjal Bhuyan heard the matter and issued notice to the centre in the PIL. On a lighter note, Justice Nagaratna made a reference to the film Wiki Donor and said that purpose was to prevent sperm donation from becoming a trade, as in the film. Congress leader and MP Rahul Gandhi has approached the Bombay High Court to dismiss a defamation case from 2017 against him for allegedly linking the right-wing RSS organization to Bangalore-based journalist Gauri Lankesh's murder. Lankesh was shot dead outside her home in Bangalore by unknown assailants. In 2017, advocate Dhruteman Joshi filed a private complaint against Rahul Gandhi, Sonia Gandhi, and CPIM Secretary Sitaram Yechury, claiming that while watching the news, he saw Gandhi's interview outside the parliament, wherein Gandhi allegedly said that whoever spoke against the BJP RSS ideology was pressured, beaten, attacked, or killed. That statement was made without any proof of official statement and had belittled RSS in the eyes of the common public. Based on the complaint in 2019, the Borivali Magistrate Court issued process against Gandhi and Yechury and summoned them. However, on the very next day, Gandhi filed the application seeking to quash the complaint on the grounds since the statements allegedly made by him and Yechury were admittedly at different places and at different times. There could not be a joint trial, and so the complaint should be dismissed. But the magistrate dismissed both applications. The Congress leader has now approached the Bombay High Court against the order of rejection and consequently to dismiss the complaint. The matter was listed before Justice Sarang Kotwal today but was adjourned to 5th December. And lastly, the Delhi High Court has pulled up a trial court in the national capital for discharging a rape accused on the basis of the results of polygraph test conducted on the victim. A polygraph test, also known as a lie detector test, is basically a method of measuring physiological responses such as heart rate, blood pressure, and skin conductivity to determine if a person is being truthful. While it is used as an investigative tool by law enforcement agencies, courts generally do not consider the test as conclusive proof of guilt or innocence. In this case, the court was dealing with a plea filed by the victim against the order of trial court, which discharged 3 persons, one male who was accused of the offence of rape and 2 females accused of causing hurt and criminal intimidation. Calling it erroneous, Justice Swarnakant Sharma said that the result of polygraph test at best could have been considered as part of the investigation and tested during the trial to check testimonies of prosecutrix and other witnesses, since such result by itself is not a piece of independent evidence. Accordingly, the court modified the order and concluded that the offence of rape was made out against the male accused, as there was enough material on record to proceed against him for trial. And charge for committing offence of causing hurt as well as common intention was made out against the other 2 women accused. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.